going to record on the. Okay. And Deborah's letting those folks in. I'll give you the CLE at the end. We're recording. I'm going to post the PowerPoint on my page of the website. If you would like to change your view to speaker view, that may or may not assist you. And that just means that you will see more prominently those of us who are speaking when we're speaking. Understanding, of course, that once I start sharing the screen, you're going to see mostly that. All right, so I'm going to get started. Thank you for being here. Lisa Bedwell, who's our rockstar. Wait, somebody needs to mute themselves. Okay. Lisa Bedwell, who's one of our rockstar general magistrates, is going to join me in giving this presentation. I have to give her credit for at least 92% of the work because she did this beautiful PowerPoint. When we get to the 3 slides I did, you will know them immediately and be sorely disappointed in my PowerPoint skills. So I'm going to start my slideshow, and then I'm going to share the screen, and then I'm going to share screen 2. And Lisa, you let me know if that did not work.
I don't see it.
You don't see it.
No, I see somebody's.
Wait, hold on. I forgot to hit the little share button. It confuses me every time. Hold on. All right, now you should see it.
Started sharing. Yes, there it is.
Hey, all right, great. Wait, yes.
Can someone send me the link? Everyone's using
So they're using the old link. Hold on just one moment. Hold on one moment. Hold on.
Somebody's speeding back.
There are still a lot of people who are not muted. So if everybody could check your computer and make sure you're muted, we'll get less feedback.
Okay, I'm back. All right. So the thing that we thought would never happen has finally happened. And it took a while, took a number of tries, but we have both a new alimony statute and a new time sharing statute. And Lisa, I think we need to start by talking about this alimony statute because it seems to me that's where most of the buzz is.
Yeah. Although I think it's the other one, but that's just me. This one didn't bother me as much as the other one. But this is where all the buzz is. Yes.
This is where all the buzz is.
Yeah.
So, and it's complicated in that the way you currently have to read it is with the understrikes and the additions and the things struck out. It's not the easiest thing to slog through. So, here are the highlights. We're going to talk a little bit about retroactivity because there are wrinkles there, but allegedly this applies to actions that are pending as of July 1 and have not yet gone to trial. And so trials this month, I think we're in agreement, Lisa, that those things apply.
Yeah. And that was actually, there's 2 different dates listed. There's that is the application of the prospective changes, but at the very bottom of the chapter, it does state that everything else, the PIM, the retirement, the supportive relationship, all those other changes apparently take place on July 1st. So, but I think we have a discussion about that too. So we'll get to
Yes,
that.
I know. So the durational alimony changes, I think it's right to put those in the highlight section because that's where the largest number of cases are going to be impacted, right?
Yeah.
And no prospective permanent. What does that mean, Lisa?
Well, that word is gone. That word is verboten, but it does seem that there are some exceptions to, as there are to everything. If you write enough findings, you can always find your way to some other solution. So I think that that's not maybe as grim as it seems if there are permanent alimony fans out there.
I think also that we're going to repeat what you just said, a part of it a couple of times. Findings are There's more. The ones that we had before, sometimes that you didn't need to deal with, you've got to deal with. The findings are really going to be critical. And if you're writing the orders, you need to understand what is required. And if your judge is writing the orders, you're going to need to make sure that they're doing what they need to do, because there's a lot more writing that this thing's going to require. PIM, the retirement is codified with some different and unique things. We'll talk about that. And there's formulas-ish, something more guidance than we had before, which may, we got to look at the bright side, may not be a bad thing. So talk about the highlights in timesharing, Lisa.
Well, they got in the alimony statute anyway, and it's actually dual done in the other timesharing statute. They took unanticipated out of the modification. So it's no longer an unforeseen substantial change of circumstances. It's just a substantial material change of circumstances. So there's a little bit of change to a lot of things that maybe before we would have said, oh, that's not unanticipated. But now if it's material enough, we might be able to address it.
Right. And I think you and I talked about this, because the word unanticipated had gotten really overworked and mangled over the years. And in some cases that meant you didn't think of it, or it was not foreseeable. And then other cases it meant, did they actually literally consider it? This may clean up, honestly, a lot of torment and thought that we put into that word before. But talk about the second one, because this is a big one.
This one is actually, I think, a logical change. This is where a logical change, not illogical.
Yes.
If somebody started out in a long distance plan and they moved back into the area, then that is now a basis to consider modification if it's in the best interest of the child.
And we'll talk about that more. We'll also talk about the one that a decade ago would set up, those sparks and flying and fear and grasping of hair and wrenching of gnashing of teeth. And we've all, I think, been so inured to the fact that this was coming that it doesn't seem all that shocking now, but there's now a rebuttable presumption that 50-50 timesharing is in a child's best interest. And we'll talk about that more, but that's the thing that we thought was coming down the pike is now here. I want to point out the last bullet point here. In the old days, last month, there were many factors to be considered in 6113, but you did not have to write about them all. Now you have to write about all of them. So this is, again, more writing for your judge or you or whomever is doing this. And it also means more evidence. I have lots of trials where I get to a factor. I'm like, I don't know. Nobody really told me about that, but I don't know what the solution is. Lisa, is your plan to ask more questions when people don't cover factors that you are required to write something about, or?
I was already there. I already lived there.
Yeah. Right.
I'm a prophet of the 60 pages. It's, the way I always interpreted that, because everything I do is subject to review, I was always very careful to write them all. And that's why my judgments are ridiculously long and it's a manifesto. But if you sit there, going through all of it, you have to talk about it because it's on your record. So generally speaking, a lot of those factors in my experience, because I've always written them, a lot of them will overlap. You can usually find your way through most of them, even if you didn't get any explicit testimony. And if you didn't, you can just say that. But I do ask questions, because if I have lawyers who come in here, or parties, mostly parties, because I don't usually get lawyers, they don't know what the factors are. And I will actually ask questions, because one of the things in the case law is that as a trier of fact, I have to ask those questions, particularly those factors. And they're the only ones that I will tend to run off the reservation and ask, even if they weren't brought in questions, because they involve children and I want to be sure I get it right. Obviously, if you don't come in with your alimony factors, it's a different scenario for me. I might ask those. But best interest ones, yes.
I think it's hard. Like I don't have a problem asking questions around the topic that the lawyers are asking questions about. It is a little weirder to be asking questions about factors that nobody's told you anything about, but maybe it would look like, counsel, I haven't heard anything related to factors G and H. Does anybody want to talk about that? Maybe that kind of thing. So I am worried about having remands and having to reopen cases to get evidence on every single factor that just wasn't provided. So I guess we'll have to see how all that shakes out. So let's talk about alimony. So
Judge
this,
Bennett,
yes.
there was a good question in the chat about the factors. So sometimes factors are not applicable, right? So is it okay to say this factor was addressed but not applicable for this family? Or does it have to be very specific, or do you not know yet?
So I think you could say, I don't know what you mean by not applicable.
I'm just-
There's lots of times where for example, evidence of mental health issues, or evidence of domestic violence, or evidence of giving a false report. I would say, I mean that if that's what you mean by not applicable, like I would say there's no evidence that this is an issue in this case, or something along those lines. I think it's safer now, though. I mean, in the old days, I only did that just so people knew what I thought of the evidence as to those factors. I think now, even if there's no evidence of it, I think you'd probably be safer to say there's no evidence that this is an issue in this case, rather than leaving it blank or something like that.
Got it.
So, I mean, you can't like pretend that things apply to that factor that don't, but I think your safest course would be to say this isn't an issue in this case, or that kind of thing. So we have it's stated to apply to initial actions, and the final judgments entered on or after July 1. So let's talk about the question that we discussed just a few minutes ago with Judge Spry, who was on, who I brought in a little early to discuss this. So if you all went to a seminar, or I went to a mediation 2 months ago, and there was an agreement as to permanent alimony, which we're going to find out in a minute is no longer a thing. Lisa, what do you think is the outcome when they file a motion to set aside that agreement because this is no longer a legal deal?
Well, it's you've got a lot of moving parts there. The first problem is it is a contract that's been signed. So obviously you got to consider all of that. And in that context, if the lawyers were involved in that negotiation, and I believe Judge Spry was talking about this, you know, they have some obligation to have let their clients know this might have been in the pike. But beyond that, it's also not a finalized judgment just yet. So there's that. You know, I think there's a little more wiggle room with the time sharing side of it than there is with this, because of the best interest review sort of loosening those grips of contracts. But I think there's a very good argument that if you agreed to it, you're always free to run off the reservation and agree to what you want. The statutes apply to what we do here, you know, when that hasn't happened. So, you know, I think that it is possibly an argument to be had, but I don't think it stops you from still having to go through all those questions as well.
Yeah, I mean, I think there is some, it's the extreme cases that are going to be troubling to us. I think it's the case where that 17-year marriage was presumptively long-term and permanent alimony 6 weeks ago, and now it may not even count as long-term, and certainly isn't. It's durational, and the limit is the length of the marriage. So there's probably a lot of things that would go into. I guess you'd just be looking at the fundamental unfairness of having made an agreement, whereas if you went to trial, you'd be going to trial after July 1 and you have an entirely different set of rules. So I don't know that I don't know what the answer to that is, but I'm sure that there will be some struggling over that issue.
I don't necessarily think, though, and again, this comes back to that idea of, you know, you can write your way out of anything. I don't necessarily think that permanent is completely dead as a concept. I think it's a word that's been taken out. And if you look at those exceptions, there are always arguments around it. So if you're in one of those positions where it was agreed to because it seemed to be appropriate, I think if you look in even the new version of the statute, there are clues as to where that could be achieved, regardless of the change in the law.
Yeah, well, I think you're right. Let's bring this up again when we get to that section, because I think that a judge faced with that motion to set aside would really have to do a mini trial deep dive into the equities as they apply to the new statute even. So I definitely agree to that. I agree with that. So we were talking about, and Lisa, I forgot to mention this to you, but literally this week, I was at a event and happened to run into one of the lawyers that was involved in this Valby case.
Oh, no way.
Yeah, and bitterly unhappy and thought it was very wrongly decided. But I think would agree that we're still quasi, if not stuck with the concept, we need to be cognizant that this is what a DCA case said about the issue of, the form of alimony that did not exist before when it comes to some of these questions as to what law is going to apply. Now we'll talk more about the modification situation, and I believe that Lisa and I both agree that the change in the statute alone is not sufficient to get you a modification. But I think it is very possible, based on Valby and just the general tenor of things, that if you had a independent, legitimate basis for a modification of alimony, that old permanent alimony, that permanency may be on the table, right?
Yes, I think so. But you have to still have gotten all the other stuff too.
Yeah, and of course we can credit Lisa for all the fun stuff because I don't know how to do these things.
Judge Tennis, if I can interrupt you for a moment.
Absolutely.
The question is from Judge Stacy. It seems to me if you have an agreement before the statute changes, you're bound to be signed MSA unless not in the best interest of the child. Thoughts?
So when we get to the time sharing, we're going to talk about that more. I agree with you. But I agree with you that in the time sharing, you're always going to have the best interest thing. Now, but let's talk about the time sharing when we get to that, Judge Stacy. But when we're talking about the alimony, and Judge Spry, I want you to mic yourself, and talk a little about this, because my gut was kind of your gut related to 2 months ago. I signed this agreement to provide permanent alimony. I had no idea that this was on the chopping block or that likely to happen. Everybody knew it was likely to happen. And I was told by my lawyer that this many years equals alimony permanent, and that the case law all said I was a loser.
Yeah, so I was telling Judge Tennis and Magistrate Bedwell before everybody got on that I had the privilege of teaching at the family law trial advocacy seminar this past weekend, and my my workshop leader partner was Alicia Roy, who many of you know, who's a board certified specialist. She was president of the family law section, AAML, all the letters after her last name, but she actually wrote the new alimony statute, and so we had an opportunity to talk about a lot of these issues. And unfortunately, I think this particular issue puts the lawyers in kind of a tough situation. There is some stare decisis that talks about the fact that lawyers not only have an obligation to talk to their clients about what the law is, but, and I don't have the case in front of me, but I believe the language talks about if there is a very good chance that a law is going to change at the time that parties are contracting settlement, lawyers still have an obligation to talk about that legal change. And I could contemplate seeing motions to vacate under 12.540 filed in that regards. And my gut is similar to Judge Tennis's in that I probably would look at that and consider that very seriously. And it would have to be obviously, recent to the law change. So certainly agreements that you might have signed in 2022 that haven't been adopted into final judgments yet, probably wouldn't be considering that. But anything in 2023 in my mind would be fair game, because I think everyone's or the lawyers who are paying attention know that this was definitely one of the major things in our legislative session. So
yeah. And so back to the Valby logic and modifications. If you have a permanent alimony currently in a final judgment entered, and there's a big change of incomes that would legitimize a modification of the amount, is the judge going to trigger the new durational rules and get rid of the permanency. Under Val B logic, it feels like they could do that. It does seem unfair under other logic. So I don't know what the answer is, but I do know we're all going to be kind of wrangling with this until the 6th tells us the rules around that. But just be ready for those arguments on both sides at this point is all I can tell you. And whatever you can do to argue that the equities, even under the new statute, would be best served by not making those changes, if you're on that side, is probably what you need to do.
And there's something that
Please.
bring up, if anyone didn't attend the Florida Bar's version of this discussion yesterday, there was a case that Gabriella Bonilla is bringing up in the chat, which is absolutely critical for you guys to look at. It's the Arrow Air case. The site for that is 645 Southern 2nd, 422, but it does provide you guys with some good arguments as to the statute not applying in those situations.
Not applying in the modification situation?
Not applying in the situation where there's a settlement agreement, that is entered into along the lines, right along the around the time that the law changed.
Okay.
Providing for an argument against 12.540 vacation.
Can you give that site again? Is it the Arrow Air, did you say?
Yeah, it's Arrow Air. The site, I'll go slow, is 639 Southern 2nd, 975. It's a Florida Supreme Court case from 1994.
Someone just put it in the chat.
Did
Can
you,
you
I'm sorry, Judge, what'd
It's
you
already
say?
in the chat. It's in the chat. The site is.
The site is in the chat, FYI. That's all.
So the
Can you guys still see me? My computer decided to just completely fritz out, so I'm just making sure you can see me.
oh yeah, I can. I
Okay,
can.
I'm just gonna let it keep fritzed, but I have no visual on you, just so you know.
Gotcha.
The site in the chat is different than the one that we just heard, though.
It's
That's right.
45 chat. I'll repost it.
Thank you. All right. So the duration. Wait, Miss Ron, you're
Okay, thanks.
I just muted Ron. Okay, so durations, short term is up to 10 years, moderate up to 20, and long term is 20 or more. I'm not saying those are great numbers, but we have numbers, and that's good to have numbers. Now we have. So what do we have if we don't have permanent ish? Lisa, we have temporary, we have bridge the gap, we have rehab, we have durational, and we have lump sum.
Well,
So
lump sum's like, yeah, the form of payment. It's kind of, it's a little different type of a thing.
Yeah. We talked about this, you and I. So the rehab alimony is now limited to 5 years, and you can terminate it early if the rehab plan ends before anticipated. I have yet to have a rehab case. So I think we believe that the case law related to what is necessary to get rehab alimony, i.e. a plan, is still unchanged. And so I don't think that this is going to affect very many cases that I've seen. Maybe other people are getting them and I'm just the only one, but I doubt it. So the big changes.
Okay.
The big changes are in durational. So you cannot award durational for a marriage of less than 3 years. That does not necessarily mean you can't award bridge the gap, but you can't give durational, and you must apply a couple layers of formula. So Lisa, are you able to see this now?
I can't, but I'm following along with it on my own.
No worries. So we're talking about the durational caps, meaning the duration of your durational alimony cannot last more than 50% of a short term, 60% of a moderate, or 75% of a long term. That part's easy. With exceptional additional factors considered, which is what Lisa was alluding to later, with these additional factors and clear and convincing evidence, you could see how not easy this is going to be. Please do not come in on your garden variety sat case and make these arguments, because this is really, this is clearly intended to be a very high burden. They want you to stick to these lengths. So as an example, if the party's married and the wife was 24 and the husband was 30 and they were married for 22 years, wife is now 46, durational alimony would be limited to 16.5 years, which includes the alimony that's been received, the support that's been paid voluntarily or by order during the divorce, keep in mind. And so that's kind of what that's kind of the outcome. Now, I think that your garden variety divorce alimony case, I don't think that this is going to make a huge difference. And I don't think the orders that you've been getting are going to be particularly out of whack with this. The issue is what happens when you have those special cases that deserve to be outside of the of these durational caps. And so you have to look to the specific extra factors. And then you also have to keep in mind that this is the second part of the formula, and the amount may not exceed 35% of the difference of the net incomes of the parties. So you've got to look at what the need is and what this formula gets you. And you got to pick the lower number.
And I think that's an important point too. It seems the way that it's written, and I guess we'll see how this bears out, is that the first part of the formula with regard to the length of the award, the duration of the award, that's where the extension may occur. Whereas the formula's part with the actual amount, this 35%, this doesn't seem to be a wiggly roomy type of place.
Agreed. I would agree with that. So the exceptional factors are as to duration to get you over those caps, which again, I don't know are going to be all that different than what you've been getting anyway.
Probably not, because if you consider a long-term marriage and how long this would take you to, that would get you right about to retirement. So, you know.
Right. So I do want, as a practice point, and this is, to me, this is akin to 61075, the horrible formula that you've got to figure out the marital interest and non-marital property or premarital property. Did I roll my eyes? So that formula, I want to see in the joint pretrial memos. I want to see what the data points are that everybody claims are going to be plugging into that formula. This is this is the same kind of situation. I want to see this formula in your pretrial memos so that we can get an idea as to where you're getting these numbers for, again, the maximum alimony that is permitted. Now, Lisa,
Judge Dennis?
Yeah.
So that gives you the range, right? That's the maximum. But if the need doesn't establish that maximum, just because it's at that maximum doesn't mean that that's what's going to be ordered per se, right?
So if you look at the bottom of this slide, if the actual need is less,
Yep.
the actual need is less, you go with actual need. And if there is no, and you still have to prove need and ability before we go to even the old garden variety factors, all of which must be considered. So if you don't, it's still, you've got to prove need and ability. Once you do that, we go through the regular. I'm sorry. Oh, so again, I don't do mathematics. I don't like mathematics, and I want you doing my mathematics. So if you could put those formulas in the pretrial memo so we could have conversations around that, that would be awesome.
Can I jump in with a couple of questions?
Absolutely.
Do you think it's necessary to amend pending petitions where permanent alimony is requested, removing that request so as to not have a frivolous request?
Oh, That's a
That's an awesome
that's
question.
a good
Thank
question.
you, Richard West.
That's an awesome question. What,
Ooh.
I mean, if I had my dream situation, I'm not saying that you'd have to file an amended. My dream situation would be where you would file a notice of withdrawal of the request for permanent. And if you wanted to add more details about, are you asking for the cap? And if so, what do you believe that cap is? What's the length of the marriage? What do you believe the cap at the time is? How many years are you asking for? I would love that. And I think that notice would be a really good idea. Now,
I also think it would be don't be a smarty pants type of situation and try to get a 57-105 out of that, because we're
no,
all,
yeah,
you know, that wouldn't be really cool.
no. I mean, I think most of us are doing case management at notices for trial, and I think that would be something that would be discussed there, and everybody would just acknowledge that that's not it. Now, when we get to having said that, though, let's talk a little bit more. The exceptional factors really do circle around folks that are disabled, serious medical situations, caring for children with terrible disabilities, caring for adult children of the parties that are disabled and dependent. Some of the worst of the worst situations, if you prove those up by clear and convincing circumstance, then the court may be stuck with the cap of the amount, but they're no longer stuck with the cap of the 75% or the 60% or the 50%. So at that point, I think the court would be entitled to give a number beyond those durational caps. Lisa, you and I talked about this week. In the most extreme circumstance where a judge felt like the payee needed to have alimony for the indefinite foreseeable forever, what's the kind of word? We can't use the word permanent. So what's the kind of wording that gets you to do that? Do you say just until
Yeah.
the age of one or the other, or what are you thinking?
I think your safest bet is until and unless otherwise modified or terminated. I think that's your absolute safest bet. Because that leaves open the door for things like the retirement, the supportive relationship, or the other terminable conditions that potentially exist, or modifiable conditions. Because don't forget, on top of all this, we still have the right to modify because of financial changes in circumstances.
Right.
So there's a number of different reasons that award could be adjusted. And I think as long as you just keep it vague and don't use that permanent word,
Yeah.
you're okay. I think if you start getting too cutesy with dates and times, it starts getting a little bit easier to appeal that.
Yeah, but so back to the permanent. So if you've got a situation where you have, I'm not even going to say long-term, but a longer-term marriage, but you've got some real health issues related either to the potential payee or children or adult children that payee is caring for, and you think this is one of those very exceptional, unbelievably rare hen's teeth cases, in that situation, maybe you would be better off doing an amended petition, taking out the word permanent and adding the facts that you believe that you're going to establish that gets you out of the presumptive, caps and things. I think that would probably be the safest route to go, because you want to put everybody on notice. Because if you just leave the word permanent in there, we know that doesn't exist anymore, which means you apparently mean that you're going to be happy to go along with the caps. I would think you'd be better off pleading a little bit more fully what it is that you're looking for. Likewise, but while we're on this topic, if you're, I see this all the time, people pleading for alimony now I see this on 1-year marriages, on 2-year marriages. I would be really careful to do that. And sometimes I get to case management. I'm like, how are you going to make this happen? Well, we were just doing it to, I don't know, cover ourselves, or in case they asked for it, or some cockamamie thing that isn't. I have a good faith understanding of the facts and the law around this issue. So I would be very cautious about putting in old school boilerplate requests for alimony after July 1 of this year, because we all know the world has changed in that regard. And I just think that's not safe to do anymore. let's talk about a little bit. This also, Lisa, does not feel like a huge difference to me, the weakening of the standard of living. But
No, I think they kind of came at that with the case law pretty good.
And I think that most of us act on that already, that's just two homes can't run as the same as one. But there are some additional areas of consideration which seem to be legit, including the mental and physical health of the parties, care of the children with disabilities, and that kind of thing. They also got rid of the tax treatment, which makes sense because we weren't able to do that anyway. So I don't know that any of that really is going to change much of your outcomes.
I would point out too that it's interesting to me because it seems as if this idea of the medical and physical health of the parties and the children with disabilities comes up in two different ways. This isn't just the factors, Joe factor, that you're doing in any alimony case, but that other exceptional circumstances factor seem to suggest that there would be an even more elevated examination of that. So it's curious to me that it kind of is in two different spots.
Yeah, I think that's I think that's true. I mean, I do believe that those are some of the issues that are most often really impactful in an equity kind of consideration. So I think that's right. Deborah, were there any other questions that I didn't mean to rush by you there?
Sure. I was going to try and ask them during applicable, but let's just take a little break and have them asked anyways. Amendments. Oh, wait, hold on. In the case of temporary alimony orders entered prior to the law going into effect that might have led to a higher alimony award that is otherwise available under, hold on, I have a word that's under the new statute, are the courts going to retroactively correct what was owed on the temporary orders pursuant to the statute at the final award?
So I'm going to invite any judge at any time to jump in who thinks I'm saying stuff that ain't right or that they clearly will not be doing. But my understanding is a temporary order award, whether it's voluntary or I foisted on you, is always retroactively fixable. And that's the whole point that we try to make, is that instead of having a 3-hour mini trial on some of these issues, your agreement is retroactively modifiable. My orders retroactively modifiable. So I don't think this will change any of that. If your question is, does everybody get to go in and have a second temporary hearing because things have changed? Not in Division 38, but yes, it is fixable at the end. It's very fixable, super fixable. So I think it's our obligation to go back and do a thorough job, because a temporary order is only a Band-Aid, and a temporary agreement, we understand, is often only a Band-Aid also.
I think it's a hard spot though too to remember that your status as a married person is a lot different in a temporary context than it is as a divorced person. So the status quo and the admin order and all that kind of stuff that might naturally balloon an award, you know, a lot of that is due to the fact that you're still legally technically married. So there's a little bit more of a protected class sort of status. I don't know how else to put it, but to a person who's asking for alimony in those conditions. And I think that we got to be very mindful not to allow people to abuse the temporary alimony process just because they know that there's no carrot at the end of the divorce itself. I think you got to be really careful with that. It's not really a problem I have down here in Brokeland, but upstairs, you guys got to be mindful that people might use that as a means to try to extend their case.
Yeah, well, except that the support that's provided, either voluntarily or involuntarily, counts against the durational cap. So and I acknowledge that I haven't done a thorough analysis, but probably your typical alimony award now may not even be reaching that cap. But yeah, I have great concerns about cases where there's clearly not going to be an alimony, it's not an alimony case, and yet the standing administrative order is essentially used as a way to get a support that would otherwise they would not be entitled to for a longer time because the case takes forever. It's definitely a concern of mine, definitely. All right, so I read the adultery sentence in the new statute as requiring an economic impact. Now, I think you could read it that and as being you can consider adultery and you can consider the resulting in economic impact, but I don't think that's what they meant. I don't think that this is out of line with what the case law already generally is. I think they mean if there's an economic impact, you could consider adultery. I really hope they don't mean more than that.
I can't imagine. So they would totally invalidate the whole, like, you know, the no fault state thing, but you know, when is the last time that they did anything poorly drafted? One wonders.
I think they mean it really needs to be financial.
I hope so too. I think that because that may make the most sense. That's what the case law says.
So we're going to talk more about the supportive relationship in relation to a modification action, but they also have included this as something that could be considered at the final trial as well. You know, included in the any other factor necessary, and that probably makes some sense so that we don't have to deal with these things, you know, 3 weeks later in a modification action. So there's that to be considered. Okay, going on.
Can I back up for just 1 second?
Sure.
With regards to the durational period of time, does it include payments of 1, voluntary support, or 2, temporary support paid by way of a temporary order?
I believe it does.
I think so too.
I believe it does. And to me, that's not illogical. I believe it does. So if there's child support, so this, I find this to be a little bit weird, but yes. So I'm working on retooling my final judgment template, because if there's child support paid through the state and alimony is not included in the IDO, but only child support is included in the IDO, then the final judgment or the order awarding alimony must state that either party can request the alimony to go through IDO. Now, it would probably be just safer to add the alimony to the IDOs, but just so you know, that has to be in there. And then there's more, there are specifics that we're going to dive down into related to health insurance and kind of those kinds of things. So take a look at that section. If there's no child support, you're not required to do alimony through the state, by the way. You're not required to do that, but you can. Let's talk about the supportive relationship, because there's a few huge changes here when it comes to modifications based on supportive relationship.
Yes.
I think the biggest might be that the filing, you can petition, file your supplemental petition if a supportive relationship has existed in the year prior to the filing. Not necessarily exists this moment, but has existed. So what are your feelings about what we're likely going to be looking at when we get to a trial on a case where the supportive relationship wasn't even in place at the time of the filing, but had been in the last year?
That's going to be a weird area, because you're talking about people who conveniently maybe break up, or maybe don't inconveniently break up. Maybe it's just they naturally, organically ended their relationship. So are you saying because of this now that they should be terminated from their right to support because for 4 months they had a relationship with somebody within the last year? You know, it's kind of, it leaves a lot of room for that argument. I think that was the big concern that we had shared about that. There conversely is the good side of that, which is I think what they were trying to get at, was these people who do have such relationships and then try to under the table them while the case is going on, and then they come out into light after the case has been finalized and they shamelessly collect their check. I think that's what this was kind of aiming toward, but I think it might have created this inadvertent side effect that we're both kind of leery of potentially.
Yeah, I think this is real. I totally agree with you. I think this is really tricky. I think if you're the lawyer representing the person defending against the modification who says, no, 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 we broke up yesterday. Didn't I mention that? I think you really need to do some due diligence, because I can envision, this is just an area in general where I feel like lawyers are sometimes surprised by some of the stuff that comes out in court. And I could certainly see this as an area where no, 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 we're not together anymore. And then all of a sudden you're looking at pictures of them, you know, canoodling at Disney last week or whatever. This is going to be very tricky, I think, to try to ferret out whether or not that relationship that existed means this person is no longer in need of support or has become self-supporting.
They did slightly tinker with these factors as well. There wasn't enough space to keep them on all these slides. So just be mindful of that as well. There was a little bit of changes in this area.
Yeah.
Sort of loosened it up a little bit, but it's still not the easiest thing in the world to prove.
Yeah, agreed. It does give you some guidance on the things that we're looking for. A lot of the things that you would expect, you know, finances together, living together, paying for things together, holding themselves out as spouses in public. That would be really dumb in this day and age. But, you know, all of the, you know, most of the things that are pretty logical and that you would expect to be looking for. If there's a finding by the court of a supportive relationship, it is not discretionary that we do something. Now, it doesn't tell us what we have to do, but it is not, it is, we must do something. So I don't know whether that runs the gamut from this person is, you've got a new artist boyfriend who's living on your couch, but every 3 weeks he buys a thing of milk, and so I'm going to reduce your alimony by $100. Or if this is, you are now got somebody that you're supporting, that means you're no longer should be dependent on somebody else. I'm not sure what we have to do, but we have to do something if we make this finding. The burden is on the obligor to prove a relationship existed in the year before he filed the modification or the action. This could apply to the initial action also. And then the burden shifts if he proves that to prove by preponderance of the evidence that the court should not terminate things or reduce things. And it goes back to the other factors. Oh, but it does add this factor. I think this is new. Somebody check me if I'm wrong. I think this is new. You can also consider whether the obligor is current on their payments. And I think that is really fair, because you can't come in and say this person's become financially dependent. They've got to shack up with this person in order to try to keep the lights on, because I'm not paying what I'm supposed to be paying. So I think that's a very, very understandable and logical and good thing to have added.
Also, Judge Tennis, I think it's important to point out that it doesn't necessarily mean it has to be a romantic relationship.
It has to be a supportive, yes, and not family, and not.
But they don't have to be dating, is what I'm saying.
I think they do define that in there a little bit more clearly. It was a non-related individual.
They do, and I take, honestly, I take it to be a not a husband and wife, but I take it to be a romantic, emotional, supportive. You've got a. Judge Spratt, what do you think about that? I still think it has to be like a relationship, not I've got a boarder, or my cousin's helping me, or my mom's sending me money.
A romantic relationship. The case law talks about the impact that continuing financial support from a non-romantic third-party relationship would have on imputation of income.
But isn't that different than a supportive relationship? Isn't that just your need has been reduced?
Different creatures. I think the alimony, even with the new alimony statute, you're looking at a romantic type relationship. I think the case law talks about third-party types of support, a la rich mom and dad continuing to fund the lifestyle of an adult child.
Yeah. So I think any relationship that is reducing somebody's overhead could be used in a variety of ways. So gotta give Lisa credit for with this one because it's really funny.
I love that movie.
I like it too. All right, so we now have PIM codified. So this is a retirement or imminent retirement.
Right.
So Lisa, we talked about this. So what it says is you got to be retired or have shown demonstrable and measurable efforts or actions. What is that going to look like?
They don't define that because why would they? I think when we were discussing it, like on our own, one of the ideas I had was like drop in the state, but like you said, that could go on for years. So, that doesn't really help you much. I think what they were getting at was that it has to be something imminent that's coming soon, and that you've made definitive steps with your employer that you could support with evidence. These are the steps I have taken to part ways with them. And that in turn could be used to support the argument that you are in fact going to retire, and not just saying you're going to retire and then continue to work in a job that maybe you don't need. Sorry, I'm starting to get political now. You need to actually have shown good faith effort to have done the thing, and not like pretend that you're going to do the thing and then change your mind.
This is really going to be, the sticking point.
Yeah.
I promise, I pinky swear, as soon as you sign the order, Judge, I'm retiring.
And then they don't, because of what? Did they get more money? Well, in that case, why am I stopping the alimony? Or did they decide that they couldn't live as a retired person because it was boring? Okay, that's fair, but then now I just stopped your alimony. I think there's no real safety net that I can see just yet for if that happens in bad faith, which I guess is where the litigation will have to come in and come behind it.
And if your typical modification litigation isn't going to be over,
I get it.
say it's a year. Say it's a year later, you get to trial and you haven't retired yet. Well, then when is this thing going to happen? Now, I think you could also legitimately say, like, I can't retire until you tell me I don't have to
Until you order.
Yeah, until I don't have to pay it. But we're going to need I'm going to want something. A letter to your employer saying on this date, my intention is to retire if I'm allowed to. I don't know. This is going to be very difficult. Or maybe you reduce to some nominal amount.
That might be the better way to go, to just do it like almost like the nominal award that we used to do with the permanent.
Maybe that.
That might be the better way to go. Just say it's down to a symbolic $1, and if you decide to work again, guess what, Toots? It's back. Game on.
So the obligor has to prove by preponderance that it reduces their ability, and then the burden shifts. That's pretty much as you would have.
And it does say terminated or reduced. So arguably you could go with the dollar route. That would be what I would argue if I were the obligee. That would be where I'd run, because you don't want it to terminate outright, because then what happens when they go, just kidding, I'm going to work until I'm 85.
Yeah. Now, of course, let's point out, on final judgments entered from here on out, we're already entitled to look at retirement as part of the durational. So I would think there would be, as time goes on, fewer and fewer modifications based on retirement, because you're going to have more final judgments with alimony that stops at some period of time that is short of or right at or around retirement age. So that may assist.
And arguably this one and the supportive relationship one and everything else except for the new durational changes, all that case law should still be good. There is enough stuff, because this is one of the more hotly litigated areas, that should guide some of these questions already. So hopefully. Right.
I would agree with that. Okay, so we talked a little bit at the beginning, the new timesharing modification. We've taken out the word unanticipated, so now it's just substantial and material change of circumstance. Will that, I don't know that it'll cause more filings, but it may cause less dismissals.
I think that's true.
I think that might be the
We're gonna
case.
have more hearings.
And then the other, I mean, one of the other big ticket items in the new time sharing is the 50-mile thing.
Yeah.
So Lisa, we talked about this. I don't think I think we both see this as maybe not such a horrible thing.
No, I think this is a good change. I think this is a good change. It
Um,
always made sense. And there was a whole line of cases about it saying that, well, that's not unforeseeable, but it didn't feel right. It just felt gross. It's-
and we're going to talk about in just a second, we're going to talk about the 50-50 interplay with the 50-mile thing. So I'm going to come back to that if you've got questions about the interplay between those two things. All right. Yes, we're going to talk about all the time sharing stuff. Yes. Yes, because while everybody was agog about the alimony thing, everybody was like, oh, wait, look, they took the 50-50 out of the alimony bill. Well,
Not really.
not really.
They
Not
just took it
really.
somewhere else when you weren't paying
They
attention.
just put it somewhere else. Okay. We just talked about that.
Some of these overlap, some of these changes
Okay.
in your bill
So
overlap.
just keeping in mind, there's a lot of case law that says moving isn't a big deal. Ignore that. If you were outside 50 miles of the custodial parent and now you're within 50 miles of the custodial parent, your moving is now a big deal. And I take this to mean what the case law generally says about 50 miles, and that is as the crow flies. So take that in mind. There's a rebuttable presumption that equal time sharing is in the best interest. So if you have a party, Lisa, that moves within 50 miles of the custodial party, and therefore there's a modification, they've modified under a legit term under the statute, do we now go to this new rebuttable presumption that equal time sharing is in the best interest?
Well, keep putting aside the timing issue in a second. We'll get to that in a second. I think you do, but as with everything, you can write your way out of just about anything you want. And it really depends on where in that 50 miles you're going. I mean, there's a lot of power in discussion of logistics. And if, let's say you moved within 50 miles, but you are over in Groveland and your co-parent is in, I don't know, Lake Nona. Sure, that might be 49.8 miles, but is it really in the child's best interest? And this is the distinction between a 50-50 being presumed to be in the best interest of the child as opposed to a parent, because those are different concepts. Is it really in the child's best interest to get up in a car and drive from one parent's house to the other 5 days out of their week because that parent had to have an equal schedule that was formatted week on, week off? Are there alternatives? Yes, there's other alternatives. You can do different types of constructs of overnights to minimize the amount of time the kid's in the car. You could possibly do this thing a lot of people do with the school in the middle, but I hate that one, and I'll tell you why. You have no guarantee the school in the middle is going to stay the middle or that it's going to be something that the child's guaranteed to be enrolled in, because yeah, we have school choice and vouchers, et cetera, but if you don't do what you need to do to get in there, maybe the kid is waitlisted or something else happens, or maybe one of you moves again. That's no longer going to be a good solution either. So I always choose one household or the other, and not granny's house or somebody else's. It has to be a parent. And invariably, one of the two parents is going to be inconvenienced by that. So to me, that's a huge thing for me is the logistics of a child and the time they have to spend in a car, where their community of record is, where their activities are, where their friends are. These are things that matter to children, and that a 50-50 presumption will skip right over if you let it.
So
But
yeah,
that's why the factors still exist.
So I agree with all of that. And I think that the folks moving within 50 miles is going to be a big uptick in cases.
Yeah.
And the fact that we can't get rid of it because moving doesn't mean anything is going to be a lot more cases going to trial based on that issue.
Right.
And I think that once you get a legit modification because you've moved within 50 miles, the presumption applies. But what I want to have the lawyers do more of is really flesh this out, and the things that Lisa's talking about, the logistics. If the person has lived in, Guam for the last 10 years, and now we've got kids that are in middle school or high school, and you've been away for 10 years and now you've moved, even, I don't even care if it's down the road. That doesn't, that presumption, there's a lot of reality that's going to get you around the presumption. The presumption can be rebutted by a preponderance of the evidence. So that does not mean that this is every single case is going to get this. And just because you've moved back to town doesn't mean that you're going to get this. And it really is kind of irritating. I'll be honest with you. I don't know that there's probably not a judge that's more likely than I to do a 50-50 schedule. There may be a lot that do similarly, but it still irritates me when I say at a case management or whatever, like, what is it that you're looking for? Well, they want a 50-50. Well, you just told me he works nights. Like,
Yeah.
what's the schedule that you want, and have it make sense to me, and don't have it be some sort of like, well, I want to be, that is a turnoff. That is a turnoff. So if you're moving to town, I want to know things about the distances and all of those other things. I will say, under the heading of know your judge, like I happen to like, and I make people pick a school in the middle with some frequency. So that's a thing that you need to know about the judge that you're in front of. And if you don't know it about that judge, then you haven't been gossiping enough. Ask for a case management and say, in the world of options, they're within 50 miles, but it's a 45-minute or an hour or an hour and a half drive during rush hour. These are the school options. We've got Orange County, one person, Lake County. Find out what your judge thinks about those things before you go to a mediation where you're all, you're making decisions without knowing what it is, the proclivities of the judge that you're going to end up in front of. So
I would suggest too, if you're going to do that, find your outs and your alternatives, because a lot of times I will get those on post judgment and they will be problems because it's fallen apart. So try to anticipate, well, if this isn't available until the judge can review it in the best interest of the child, this is our default solution and the alternative to that, and come up with something, because then you got these kids who've got no enrollment and school's started. And
right. You've got emergency motions being filed today on an issue that it's just.
And before that was foreseeable, but now it's not. So,
Yeah. All right. So let's talk a second about gosh, I'm so sorry that I'm running over. I just want to talk about one more area that is, I'm going to tell you the way I read it. I had an argument just this week with a super lawyer on this subject. I don't know if they're here, but you're welcome to pipe up if you are. I understand that this is controversial. Judges, if you're on the line, I welcome you to pipe up also. You know, this is my slide because it's boring. So, oh wait, no, hold on. I need to go back on. So 744, which I believe I sent you. The sentence that is important to me for this purpose is, if the father has not established, and this is a new sentence, it was added for a reason. If the father has not established paternity via 742, meaning petition to establish paternity, I'm found to be DNA, I'm found to be the father, or 742.10, which is the establishment of paternity for children born out of wedlock. That's the statute that tells you that if the parties sign the affidavit at the birth of the child, the father is presumptively the parent. If you haven't done one of those things, sir, then the mother is the natural guardian and entitled to primary residence. I take this to mean that if the parties have signed the affidavit at the birth of the child establishing paternity under 742.10, then they are on equal footing. Just like divorcing people, they are on equal footing. I'm going to add 742.10. So that's what I think. And I think that means if he's on the birth certificate because they signed the affidavit, that Nelson versus Mira would be no more, meaning the mother would not have a right to an ex parte pickup order if dad's on the birth certificate. That's not to say she doesn't have a right to a pickup order, but she doesn't have a right to an ex parte pickup order. Judges on the line, discuss. I know I've got the
Judge
judges.
Stacy
Yana-
agrees.
Judge Stacy, do you agree?
I agree. I concur.
Judge Spry?
Thumbs up.
All right,
Leach agrees.
all right. Is
Judge
that,
Laurent, they're in the, we're in the chat, but yes, Judge Laurent, I agree too.
okay,
Judge Michaela Nix Walker, I agree too.
so that is the way we're reading it. Now, I'm not saying that the sixth at some point is going to tell me I'm wrong. I get it. But that's how I read it. And I think that I read it that that was intentional. I mean, that they're wanting to put fathers on birth certificates on the same footing as moms. So what I think it means is not that you were getting all that many ex parte pickup orders anyway, but I think it means you've got to have a hearing and something more than I'm the mom. If he's on the birth certificate, just like you would if it were a divorce case. And I think it also means that if mom is served with paternity action, he's on the birth certificate and she flees the state, I think he may have a right to an ex parte pickup order. Again, most of us are probably going to require a hearing for that, but I think he's going to have more of a right to a pickup order with this new statute change because he's on equal footing with the mother if he's on the birth certificate.
Can I jump in? Is a form of clarification that's been asked in the chat.
Sure.
Under the new standard, father can get a pickup order or have time sharing granted if an injunction is entered, if he's on the birth certificate. And do you need to file a copy of the birth certificate into the court file in order for that to be granted?
Great. That's a great question. I'm so glad that they asked that. I believe it does. Now it's going to be a little more unwieldy in the injunction setting. And I think generally, well, here's what I would say about that. If there are still judges in the injunction divisions that are saying, I'm not going to deal with any time sharing because you're not married, then, and they have in front of them a birth certificate where he's on it. Yes, I think it's going to change the outcome. I mean, you're going to get them dealing with those initial time sharing situations. It's my gut that already those things are being dealt with largely by kind of agreement or acquiescence or whatever. But yes, I think that would make impact that this statute would impact the injunction situation. The birth certificate question is a fabulous one. And yes, I wish that we saw those more often because as Lisa Bedwell was pointing out to me when we were talking this week, there are times where even though theoretically there should be the affidavit signed to get on the birth certificate, that they're not, it doesn't always happen that way. And the converse, there's sometimes where the child has his last name, but he's not on the birth certificate. So I think particularly if you're the father, yes, file the birth certificate. Lisa?
It's not the birth certificate that's doing this. It's the affidavit that you have to sign as an unwed parent to get on the birth certificate that's doing this.
Although so this
But sometimes the hospitals don't do that step. That's what she's talking about there.
Right.
Yeah.
Right. And so while it's true that we're talking about the affidavit and not the birth certificate, if I had a birth certificate that he was on, I'm going to assume they signed that affidavit until somebody files the affidavit, which is I don't know, it's on the back of it. I think it's on the under it or whatever, but it's the part we don't normally see in the file. But if somebody filed that and he wasn't on it, that would change things. But I'm going to assume that they signed it if he's on the birth certificate.
It's one of those things that the hospital's supposed to do, but doesn't always do. It's along with that thing about like the refusing the information on the husband and stuff. The other thing too, we talked about there is that potentially could work in reverse because there was a whole bunch of case law that had said that you can't do an ex parte or not ex parte. You couldn't do a pickup order for a man who had not yet had his paternity adjudicated under the old version of the statute because that was improperly giving him rights and not putting mom on notice, et cetera, et cetera. And I think that's all gone now because if he has got this kind of standing, then it might potentially open that door. But it does not change anything if he's not on there or hasn't done any efforts. It's still the same old mom is the boss thing.
Yes, absolutely true. If he's not on the birth certificate and has not gotten a final judgment of paternity, it's still mom is the boss thing.
So if he's on the birth certificate but didn't sign the affidavit and you have proof of that, then mom becomes the boss, or because he's on the birth,
So theoretically, the statute says affidavit, not birth certificate.
right?
Right.
I think that is going to be a very rare occasion, but the statute says affidavit.
I think you'd have to know you have a really sloppy hospital for that, because I'm sure they have some sort of piece of paper.
Yeah, I'd be looking for mixed kids at that point and probably do some DNA testing.
Just tennis, man, may I make one?
Sure, please.
One thing we probably need to remember is on 744, there was a provision added, obviously, that basically provides that the mother and the father who's established paternity, whether it's under 742.011 or 742.10, are the natural guardians and entitled to and subject to the rights and responsibilities as parents. Under 742, if you establish your paternity pursuant to 742.10, you still have to file a 742.011 action to establish your parental rights and responsibilities.
Right. It
So,
doesn't stop you from having to still get a plan.
Correct.
right. But it
So
would,
those rights aren't automatic. You still have to, obtain your parenting plan, your child support obligations, et cetera, by filing an action pursuant to 742.011.
sure, but I want to make sure we're on the same point, John. What my point is that if you are filed the affidavit on the birth certificate, you are as equal as those divorcing husband and wife.
That's the intent of those changes. Yes.
Okay. Yep. Okay. Yeah. I didn't read into it anything beyond that. And I don't think it's going to make anybody, I don't think moms were getting all that many ex parte pickup orders, even with the Nelson Mira case, meaning they were setting hearings typically. And so I don't know that it's going to change things on the ground, but it definitely is a change in my mind. So not only do all the factors have to be considered, but judges cannot say, I considered these factors. There have to be actual written specific findings of fact. I think that's a great, I think that's maybe what it should have, could have, would have been before. I think that's a good change. So you have to actually make specific findings. And there's case law out there that says that, a judge can't just quote the testimony either. A judge has to make actual findings of fact, what is or is not true. And they have to relate to every single factor in 6113. Okay, so I don't know you can actually say that we gave brevity because I'm running 15 minutes over. I'm going to give the number for the CLE, and then we're going to take questions until I will be here until 1:30-ish. The number is, where's the number? Oh, there it is. 230-8061N. I'm going to stop sharing and put that in the chat, which might help you. It is, where'd it go? Oh yeah, 230-8061N. With my dyslexia, we have a 50-50 shot of that actually being right. And there's that. I will put the PowerPoint on my page. I will put this video of this presentation on my page. Deborah, were there any other?
Yes, there's a multitude. I'll just kind of run through the ones that have not been addressed or answered in the chat already. Can pickup orders be filed as a standalone pleading, i.e. no paternity case is filed and dad is on the birth certificate, but no court-ordered time sharing has been established?
I believe it can.
I think time sharing.
Yeah, I believe you can.
Okay.
The issue is it can be filed. I believe it can be filed as a standalone, but once you've dealt with it, that case is dead. That it's when they start trying to do more stuff, when it wasn't, the foundation was not a petition to establish paternity and or time sharing. But I think, but I'm really glad somebody asked that question actually, because if you're going to file a petition, an ex parte petition for pickup of the child, you better file the birth certificate.
I don't know, though. I mean, if they don't have a time sharing plan, what's the pickup of what exactly?
So 3 weeks ago, the pickup was, I'm mom. There's no order of establishing paternity. And this man, who may or may not be legal dad, has the child and won't give the child back. We get those all the time.
Right, but how does that, I mean, how does that work in just isolation either way if there's no, well, I guess it would work either way.
A few weeks ago, it worked in great isolation because she had a right under the statute
She
too.
had the isolated right, but I'm trying to think it through to like, with divorcing people. So you have what, divorcing guy A, or a woman leaves the state and takes her kids with her. Sure, we might still have jurisdiction under UCCJEA, but is that a pickup order situation? I guess it would be, because you would bring the kids back into the state.
So the two differences are husband and wife are on equal footing. They're not the ones that file the independent petitions for pickup order. What you get is the unmarried people filing those. And a few weeks ago, the mother would have a right under the statute to custody, and she'd probably have a right to a pickup order, according to Nelson and Mira. Now I think that's completely different. Now she's needing to file a birth certificate showing that he's not on it. And then I think she'd still have, under Nelson and Mira, probably a right to at least a hearing on her emotion.
I think doing any of these ex parte would be extremely problematic.
They always are.
Yeah.
They always are. But yeah, birth certificate is going to be pretty important. What else, Deborah?
I'm going to kind of jump around a little bit. We're not going to stay on topic, just to kind of get through the list. Maria Espinoza has asked a very thoughtful question a couple of times, and I promise I wasn't ignoring you, Maria. How can you entertain a motion to set aside a previously signed mediation agreement without also ordering the parties and the mediator testify? And so is a change in the law enough to breach confidentiality of the mediation process?
So the motion to set aside that I'm envisioning isn't about shenanigans during the mediation. So it's not about what discussions took place. Now, I suppose, I don't know if this is what you're thinking, I can envision a situation where the defending party says, wait, no. We talked about that new law going into effect. We talked about that being probable, and it might have even, passed this house, and that might be a thing. And my spouse at that time felt really bad about the fact that they'd had this hellacious affair, and they wanted to give me permanent alimony, knowing that this thing may go away. That's going to be a situation where I don't know what we do. That will be a problem. But the thing we're talking about is just, oh my God, I had no idea that permanent was going away. I never in a million years would have agreed to that had I known that the law was going to change. And before you enter that final judgment, I want to do over when it comes to the parameters around my alimony. And so I don't think in that situation there would be an issue with the secrecy or the confidentiality of the process. But I agree with you, the other scenario would be problematic.
Standing administrative orders, the assumption hopefully is that somebody is working to amend the standing administrative orders to reflect the change in the statute to the presumption.
Which presumption? Oh, the 50-50?
50-50, yes.
I doubt that's going to happen.
Okay.
I would be very, very surprised if that happened. I would be very surprised if that happened.
I don't think that
The last thing, wait, go ahead, Judge Fry, what did you say?
I was saying I agree with you wholeheartedly, Diana. I don't think that the statute actually supports that. We're talking about a presumption, right, that a judge is going to apply at your final hearing. So if you look at a plain reading of that statute, I haven't talked to our family. I haven't judged for the 18th yet, but I would assume that if there were going to be changes, it would be only the ones that are compelled by the statute.
Yeah, and it's just as I don't know how many of my brethren agree with me on this, but if you are going to spend the time to file a motion for enforcement of the standing administrative order, I would rather you spend that time filing a motion for temporary relief.
The thing that we didn't really touch on that I think was a real important conversation we've been having internally too is how this applies in terms of timeframes. Because when you read the statute on its face, it's a flip of a switch as July 1st, but there is substantial academic and case law interpretations of something substantive like this wouldn't take such a sudden change in the middle of cases that are pending. The question that we were having was, when we get to that point where the DCA starts interpreting all of this, which way do we think they're going to fly? And I know I already have people coming in here who see headlines and assume this is applying. And the way I've been going at it is, rather than have this big academic argument with a pro se person, I just look at the rebuttable factors and I come at it from that direction. And I just go, you know what? In reality, and not much has changed in my world. I'm still having to make all these factors. I'm still having to discuss, if I'm not giving 50-50, why that would be. I was kind of already feeling like I was in that place anyway, because it was so commonly handed out that I felt like I had to justify myself, because otherwise the parties wouldn't understand why they weren't getting something they felt they were entitled to, even though they didn't get the nuance of it all. So
Yeah.
I don't know if you wanted to talk about that initial pending thing, because we really didn't talk about it. And that was a big thing we're still discussing here in the building too.
Yeah, well, I mean, I think they intend it to apply to every case that's pending that hasn't gone to trial. So I don't know how we get around that. And I don't know how we just assume that the appellate court is not going to find that applicable. Now, ironically, to your point, I think most of the decisions, you know, the heartland of decisions are going to be the same, whether using that standard or this standard. And maybe we discuss that in our final judgments for a while. But I particularly feel bad. I mean, the statute gets signed, what, the day before it goes into effect. So if you were, you know, in set for trial the first 2 weeks in July, I mean, I have a lot of empathy for lawyers coming in, and, you know, things have changed since they prepared last week.
Yeah.
It's problematic. I totally agree.
And a related conversation about that was, what do you do with the people? I mean, and I think this falls under the people can waive it. People who came in and did not even ask for 50-50. They asked for every other weekend, or they asked for something else. And that's the trial they put on, or they never amended their pleadings before they had the trial. And it's like, do you have to do the 50-50? And I mean, I think not. I think you confine yourselves to what they asked for, because there's plenty of case law about that.
So Matt Capstraw and John Wallace were both asking a similarly good question. And that is, your trial was on June, your final judgment was entered June 30th. The law changes, the motion for rehearing is filed July 3rd.
That's a Matt question.
Ouch, eek. I don't know.
I don't think it should make a difference, though. I mean, you know.
Well, but is it I think his point is the final judgment isn't final until the time for a motion for rehearing has expired, and you filed your motion saying, hey, the law's changed in that time frame.
So you'd have to have another hearing to supplement it with more information, whether or not you're.
I really hope that doesn't apply to any case. I don't know. I haven't heard about that applying to any cases here, but
I could see it though. But the thing is in reality, how many people ask for less than 50-50 in recent memory? Not very many. I don't know if it's going to be that many people who go, oh, damn, I should have asked for 50-50.
Well, no, they asked for 50-50. They got every other weekend. The law changed the next day. Their motion for rehearing is filed the next day saying, hey, I should have gotten 50-50. I need a redo.
I think that would depend how many factors you wrote about when you decided to memorialize your findings.
Yeah. I think in that situation, if even under the new statute, you would not have done that. I think it would behoove the judge to go back, grant the motion to the effect that I'm going to give you findings under the new statute that get to the same place. But if you say, oh my God, it was such a close, well, you know, if it was such a close call, you probably would have done the 50-50 to begin with. But what about the alimony? You entered an order the week before that says you get permanent alimony. The law changes. They file a motion for rehearing within the 10-15 days. I think you probably got to do something to fix it. I don't know. I think.
Well, here's another question. If you wrote your judgment on the 30th and there's that rehearing period and you don't take the opportunity to go back and to add all the factors and findings that are required to be written now, are you putting your foot in it?
Yeah.
Not a
Here's
problem for me. I've already written everything. I always do because I always had to be reviewed, but you guys
Yeah.
upstairs didn't have that. You had a luxury of not having to do that.
Yep.
there's an older Supreme Court of Florida case on point on this. It is the Wheeler v. State case. Wheeler is spelled Wheeler. The site is 344 Southern 2nd 244. That's 344 Southern 2nd 244. It is in a criminal context. However, what it stands for, the proposition of, is it is a Florida Supreme Court case, is that the decisional law in effect at the time of appeal is decided, governs the issues raised on appeal, even where there has been a change of law since the time of trial. So it is very complicated, guys. So what I would encourage you guys to do is look up some of the case law on this issue. If you look at the chat, there is a case I cited to Richard West related to the pleading issue, because that case stands for the proposition that you really should be, if something changes during the pendency of a case, amending your pleadings. That talks about in the context of when a case goes up to appeal and then back down to the lower court. But I think it's going to be very case law specific in those types of things.
So what I hear you saying, Judge Spry, is that every single every single final judgment that was entered in the month of June that awarded after dispute permanent alimony that gets appealed is coming back.
Now, I'm saying that this is the context of Wheeler v. State, which obviously is a criminal case, and I haven't read all of the facts of it to see if this is unique to criminal law, but I am familiar with stare decisis in the civil context, which is similar. What's interesting, because in Seminole, we get to do a little bit of the civil work too, and if you sat on the civil benches, when we look at retroactivity, we're looking at two things. We're looking at not only the pending litigation, but we're also looking at substantive rights. So if you ever handle any sort of insurance litigation type cases, the retroactivity really applies looking at the date that the contract of insurance was signed. And so there's multiple things that you guys need to look at when you're thinking about should this apply or not. But make the arguments that you guys need to make to properly represent your clients. And I always think that this type of stuff is fun because it really lets you go ahead and kind of flex those advocacy chops to see, hey, what potentially could be the law. And in Orange County, which most of the folks that are on this call are kind of looking at, you guys have a great opportunity with the 6th District Court of Appeal to start making some stare decisis. So
I want to touch upon Mark Traum's point, and this is a hellscape in my mind. But what about the final judgment that is pending? And permanent alimony was a dispute. So if you had a trial in March and the court has not yet entered a final judgment, I think that case is still pending, despite the trial being finished. Now, if they made oral ruling at the end of the trial, maybe that makes a difference. Maybe, I don't know, but it may be that judge needs to reopen the case related to those issues.
And again, I think that where a good argument to be had, if you're the person practicing this in front of the judge to be made, is a lot of that stuff we were talking about before with the substantive interpretation of when this begins versus when it doesn't. That's where I think you want to focus your arguments, because those are the things that are going to end up being appealed. Those are the things that are going to end up getting us a clear decision here on whether or not this should be treated as it's July 1st, welcome to the new frontier, versus it's July 1st, everything filed from this date after is substantively changed by this modification, but everything before times maybe isn't. I don't remember the case citation.
And if you make that argument, and the judge says, I would have done things differently had it been prior to this new statute, ask them to include that. I mean, that's what we need for clear guidance is, I would have done things differently, but for being told I had to apply this new statute to a case that's been pending for 2.5, 3 years. And yes, Lori Piper, the 50-50 presumption per the statute, until the appellate court tells us differently, does apply to all cases that are still pending. And somebody else had a good question here.
Find that other section.
Mercedes, I'm going to ask everybody to answer this question for me. Mercedes wants to know if I can preserve the chat question. That's a great question. I don't know if me recording this preserves the chat or not, or if
It
there's.
does. I'll
it
do that
does.
for you. I'll do that for you.
Thank you so much. Thank you so
Yeah.
much. Yes, I will put both of those on the website. Thanks for the question.
I can't find the stupid sites. Oh wait, here we go. Han v. Han, which is 42 Southern 3rd, 945. And this is shout out to Linda Skipper. She found these. And then the other one was Smiley v. State, which is 966 Southern 2nd, 330. Those are the ones that talk about the substantive changes and when there would be application of law, et cetera. Like I said, I think there's a real tension in today's climate where everybody's favorite judge is Scalia, which I doubt, but that's what they all like to say, that, you know, there's strict constructionism of what it says versus this academic approach to what we should be doing. And it seems to me that academically, these cases all would solve these problems and answer these questions. But until we get somebody telling us that's the way to do it, it's sort of a free-for-all in the meantime.
Yeah. Aurora, your question is a good one. If you have a pending motion for rehearing, arguing that permanent alimony was inappropriate, but not specifically based on the law change, I can't give you legal advice, but I think that these are all of these arguments need to be put thoughtfully in writing, in order that we get the best appellate guidance, not based on, you know, bad cases making us bad law. But I think that's an open question.
Can I ask another question?
Sure.
With the unanticipated now gone and moving closer, if outside of the 50 miles, presumably a voluntary act, now a substantial change in the requirement, is that a substantial change to be involuntary? Is that now also dead?
No, I don't think so.
I missed that. I must not have been thinking about that straight.
Yeah, I'm not totally clear on that either. I think the only change is that whether you anticipated it or didn't anticipate it, or it was foreseeable or not foreseeable, or whether you talked about it or didn't talk about it, as long as it's a big deal, as long as it's a big change and in the best interest, we can modify time sharing.
It says substantial and material, but weirdly, you don't have the unforeseen taken out of any of the financial stuff. So bear that in mind, because there's a whole bunch of case law that talks about foreseeable and contemplated and all that kind of crap. And that's more on that financial side of things. I don't think that ever applied here, but just bear in mind that word still exists out in the world, just not in time sharing.
So Karen Middlecoff, in answer to your question, until the appellate court tells me differently, if you came in on a modification on a permanent alimony case based on a change of incomes, and I felt that you'd proven the case related to changing the amount, that would not necessarily, in my world yet, say you no longer get permanent in either, unless there was an additional grounds related to the duration. Now, if the appellate court says once it's opened, you got to use the new statute, you know, lock, stock, and barrel, then I guess we'll deal with it. But that's my gut for the moment.
Judge Tennis, this is Jennifer Frank. I have a quick question.
Yeah.
You know, in section 11 of the 6108, it says that the alimony statute, the new alimony statute, applies to initial petitions for dissolution of marriage pending on or filed after July 1. To me, an initial petition is not a modification. It's like getting divorced, right? Or they're not modifying anything. So I wonder if that answers the question. I've been asking around this question. I don't know if somebody else has an answer. The answer I'm getting is that you can use the new statute as to amounts, but not necessarily as to duration or the type. But I still, it's a mystery still.
I don't know what I think about that.
Confusing.
I just think that under the case law, the legislature made a clear intent that it was to be applied retroactively versus the changes regarding the modifications. And then it's a question of whether you're going to argue an appeal that it was substantive, a vested, or the equities or whatever at the time is pending. Because I think the hard case, as Judge Tennis clearly said, is those cases that all the discovery has happened, everything has happened, and then you have a trial or your trial already happened and you're waiting for an order. And I think that's where the more difficult cases for appeal are going to come.
Well, and you kind of, yeah.
That's what that Han and that Smiley case we're talking about, some of that. That's why I was saying, if you're going to argue it, that's a good idea to cite those things, because you're creating a record, and then that record in turn is the thing the DCA can make a decision about. That's much more helpful, I think, than just going in and just saying, well, it just says July 1. I think you need to have a little bit more meat to it so we can get a little more guidance.
A judge in Brevard County requested that I prepare a memorandum of law on the retroactivity. So if anybody wants that, I have like 36 cases and a memorandum regarding retroactivity application of a statute.
Yeah. So this is an ongoing conversation. We'll have a seminar on this when we've got some case law out there that will probably help, I would hope. And as I said at the very beginning, I will send out through the typical means the information about the seminar that I will put on with my JA Elizabeth to talk about AI calendar issues, and hopefully that will help you all deal with that transition. And thank you very much. I hope we've helped rather than hindered, and I will get this stuff posted for you next week. Thank you very much, Magistrate Bedwell, and thank you very much, Magistrate Korleski. Thank you very much, everybody, for joining us here today.
Thank you. Can I just say, just before everybody starts dropping off, which they already kind of have, we've never, ever in the history of this third Friday of the month had 269 at the height of our participants in this meeting. So thank you so very much, Judge Tennis and General Magistrate Bedwell. You guys did an amazing job, and there's been so many requests for a continuation of this dialogue. And so, we'll certainly point them to your page, Judge Tennis. I just very quickly want to let everyone know just one upcoming event, or actually two, for August. You'll be getting emails, but just please, if you haven't seen the emails, we have created a new Gmail account for the OCBA family law section. I'm assuming since you're on this meeting that you're getting those emails, but if there's anyone else that wants to be added to the list, please just let us know. We will be glad to add them to the list. In August, we have two events. On the 16th, we're having an in-person, like human bodies standing in the same room within arm's length of each other at the iWorkspaces venue, which is Conti Moore's office. There is an Evite link in the email that went out. We'll be sending those out again just to make sure everybody's getting it and everybody's getting the invitation so that you can make plans to attend. And then on August 18th, which is just a couple days later, we will continue our Zoom series. And it's actually going to be a joint CLE with the Estate Planning Committee. And our very own Karen Middlecoff, if she's still on the meeting, will also serve as a speaker at that meeting to talk about trusts and prenuptial agreements. So that's all I really wanted to say. And thank you so much, everyone.
Thank you. I know we didn't get to every single question. Aurora, if you're still on the motion about the GM motion to vacate thing, shoot me an email at the division about what it is you're thinking about, and let's see if I can get something out that would be helpful to you until we can do a proper seminar on that kind of thing. All right. Thank you all very much. Take care. Have a great weekend.
Thank you.